Good afternoon, ladies and gentlemen. This is the Municipality of Anchorage Board of Adjustment meeting of June 14, 2016, pursuant to notice. And we should first attend to a roll call. Would the clerk please call the roll?
Barrett Goodshow.
Here.
John Haxby.
Here.
Robert Stewart.
Here.
Also present is Julia Tucker, Board Counsel, and Lisa Slusner, Deputy Municipal Clerk. We have a quorum.
Thank you, Madam Clerk. We have an agenda, and I would like you to take a quick look at it. It is very simple today. Are there any additions, changes, deletions to the agenda?
None.
None? All right. So I will order the approval of the agenda. The next item is the minutes of the meeting of May 18. And you have had an opportunity, I hope, to look at those minutes. Are there any additions, changes, deletions?
None for me.
All right, so the minutes should stand approved by unanimous agreement of the members of the board. The next item then is there any old business that we need to discuss? Anything we need to bring up? No?
No.
We then come to the exciting new business, and that is basically why we're here today. And that concerns the BOA appeal case number 2015-2, Planning and Zoning Commission Resolution 2015-041 for case 2015-0057, and that's the case that's commonly referred to as the Northern Access to the University and Medical District. And specifically what brings us here is a motion for reconsideration filed by the appellant on, I believe it was May 23 of this year. Now, neither the ordinance nor the procedure by which this board operates provide for reconsideration. The old code provided for it, but the new code does not. And so that was the first issue that we had to overcome. I have concluded as the board chair that the board has inherent authority to reconsider any decision that it has rendered. And so I decided to accept the motion for reconsideration. Now, reconsideration of a decision involves a two-step process, and we need to be careful that we follow that two-step process. The first step is to decide whether we want to reconsider at all. Assuming that we get over that hurdle and there is a motion that has passed to reconsider the case, then the next question, of course, is what should we do now? And there are various alternatives that are available, and when we come to that, I will discuss those alternatives. So by way of saying that, and by way of introduction, then I will entertain a motion to reconsider the order of May 20, 2016.
Mr. Chair,
Yes, Mr. Stewart.
I move to reconsider the Board of Adjustment's order of dismissal dated May 20, 2016, so we can get into the discussions on this.
Second.
Okay, has been moved and seconded. Mr. Stewart, address your motion, please.
Okay, well, initially, I was of the thinking that because the issue of reconsideration was not in our current version of the code, that we didn't have that authority. But after looking at the cases that were provided in the appellant's brief and information provided to us by our wise counsel, thank you very much. I've concluded that we do have that inherent authority, and we have that inherent authority because without that, there would not be a fair administration of this order of dismissal, because you still would have that, the P and Z finding and their decision, that would still be on the record, and that still could be used. Could be used both as a precedent, and because it's there, and we don't have the ability to, if we didn't have the ability to review it, there would be no appeal reviewed on behalf of the appellant.
Okay.
So I'm just looking at, this is a way to get us back to the status quo. And that's the purpose of, that's the reason why I made the motion to reconsider, to look at all this.
Thank you. Mr. Hagsby?
Well, even though the court cases appear to tell us that we have the ability to invalidate a previous decision of another body, yet they don't. Yet current law or current code doesn't allow us to reconsider as a board. So we can, if we consider it and we invalidate P and Z for a mootness issue, from what I look at, the way that I look at it, then that's our right when we consider it. The current code doesn't give us the right to go reconsider. So it gives us the right, current law gives us the right, it would appear, to render a decision on a moot point. Okay, mootness, and invalidate the lower body's deal, but it doesn't give us the right current code or current law. It doesn't give us the right to go back and reconsider. It's the only point, the only point that I have.
Okay. So, do you intend to vote for the motion or against the motion?
At this point, I will vote for the motion.
Okay. I should announce for the record that I intend to vote for the motion as well. While it is true that the code does not address the issue, and for some reason it was left out of the new code, and we have not had time to really delve into the reasoning for it, I think there is an inherent power that a board has to revisit its decisions, regardless of whether it's provided for by code or not. And so I think we have the power to reconsider, and I intend to vote in favor of it. Ms. Tucker.
Thank you. Through the chair, just to assist in bridging Member Stewart's comments and Member Hagsby's comments. The new code does have what Mr. Stewart alluded to, and that is under 2103-050A9. Talks about procedural changes, and it says upon timely application and for good cause shown, the Board of Adjustment may relax or modify the procedural rules. So that, I think that was the bridge, and I will also point out, just in terms of the issue of whether the board has, or any deciding authority has jurisdiction to reconsider, in my work with not only this board, but federally regulated private companies and a number of other things. I've always advised my client that whether the code or a federal regulation specifically spells out reconsideration, if it doesn't say there's no reconsideration, then it's good public policy to have any decisional board exercise the ability to reconsider a decision, because there could have been a total misunderstanding, and so you want to be able to do that. And that argument has been successful with various federal regulators in
Okay.
other things.
Thank you.
To support your
Yes,
point.
thank you so much, Ms. Tucker. Any further discussion? Yes, Mr. Stewart.
Yeah, I went back and looked at the old code, and the old code specified, or had special rules of procedure. And that rule, or the special rules of procedure there, did talk about reconsideration. They included reconsideration. And those rules of procedure, then that same wording is used in in 2103-050A9 that she quoted. So that's where I made that connection to.
Okay, any further discussion regarding the motion? Seeing none, are we ready to vote?
Yeah.
Madam Clerk?
Baron Puccio?
Yes?
Robert Stewart?
Yes.
John Hacksby?
Yes.
All right, and the motion passes 3-0. 3-0. So, having decided to reconsider our decision of May 20, 2016, the question then is what to do next. And that is, as I alluded to beforehand, that's the second step in a reconsideration proceeding. We could do simply nothing, in which case the reconsideration motion really fails. The effect of that would be to leave in place unchanged the decision of May 20, 2016. The alternative is that we modify the decision in some way. Now, the motion for reconsideration that was made by the appellant seeks two items of relief. First one is it seeks a decision or our order to vacate the planning and zoning decision. And as a second remedy, the appellants ask for an order directing the return of monies paid by them. I would like to divide these two matters into two logical issues and address first the issue of vacating the P&Z decision. And so, as I said, if there is a motion made to do so, the motion needs to address the remedy that is to be provided. If no motion is made, then the reconsideration will fail altogether. So, by way of doing it in this fashion, I will invite a motion to reconsider the decision of May 20, 2015 by directing that the P&Z decision on which the appeal is based be vacated.
I so move.
Okay, been moved. Mr.
Second.
Hagsby has seconded. Mr. Stewart.
Okay, this goes back to my idea about keeping that P&Z commission decision in place. Because in place, it doesn't have a fair result when you follow it through. If you vacate the decision, then everybody's at status quo. They can, P&Z can rehear the case. DOT can reapply, or any other agency can reapply and use DOT as a subcontractor, however they want to do it. But by vacating, that does put both the appellant and the appellee on equal grounds, as though they had not been through this process. So we put everything back to status quo prior to the actual hearing.
Okay. And so you intend to vote
I
in favor
intend
of
to
your
vote
motion? Okay. Mr. Hicks.
Well, I have a few questions, really. Does vacating it mean that the decision is invalid?
No, it's withdrawn. It is ordered not to exist.
So
It
they
is
have-
vacated. The
so-
decision is vacated.
Okay, so do they have to go through the rehearing process, through all the public process again?
If that motion passes and the
So if our
P&Z
motion
decision, let me
passes-
just finish. Let me put in these terms. If the motion, if our order directs P&Z to vacate its decision, it requires the applicant, in this case DOT and PF, to refile a new application. It can no longer resuscitate, revive the application that it filed in 2015.
Okay, so it basically goes to zero, everybody starts over again.
Exactly, just as Mr. Stewart said.
Gotcha. Okay, all right, I got it.
Okay.
My discussion, I would vote, I'd intend to vote for it.
Okay. All right, Mr. Stewart.
Yeah, one other point. We are not discussing the merits of that P and Z decision.
Nope,
All we're doing is looking at whether we want to vacate.
yep. I
That's all we are
understand.
doing.
I understand clearly. I'll vote for it. I
Okay.
intend to.
All right. I intend to vote for it too. I must tell you, until I did a little bit of work and reviewed the memorandum of the appellant carefully, I was not aware that there is a doctrine of vacatur in existence, and basically it provides, and it originates under federal law, and it prevailing party voluntarily moots a case without the appellant's acquiescence. The appellant, through no fault of his own, is prevented from obtaining appellate review of his claim. The Alaska Supreme Court has followed that federal practice, and in the case cited by the appellant, City of Valdez versus Gavora, the Alaska Supreme Court said, "We agree with the United States Supreme Court that the principles of equity require vacatur of the challenged order in a case where a prevailing party voluntarily moots a case without the appellant having done anything to bring that result about." When we first discussed this matter in May of last year, I wasn't aware of that doctrine. If I had been, or if any one of us had been, we probably would have addressed the issue right then and there. So but because we weren't, it wasn't addressed. So I'm very appreciative of the appellant bringing this to our attention, and I think this is an appropriate case where we should exercise our equitable power, which it is under the court decisions, to vacate the decision below, that is the decision of the Planning and Zoning Commission. And I think the appellant has done, well, I know the appellant hasn't done anything to bring about the mootness of the case, and so the appellant shouldn't be penalized for DOT and PF having done that. So I think it is appropriate to vacate the case. And so under those circumstances, I intend to vote in favor of the motion. Is there any further discussion?
No?
I would like you, no, I think we are there. And Madam Clerk, would you please call the roll on this motion?
Excuse me, Chair.
Yes, Ms. Tucker.
Do you want to follow?
I see what you're saying. And I think, Mr. Stewart, you're the one who made the motion. And I would like you to supplement your motion by reading into the record the proper motion, the way it should be worded, the way I would like to see it. And that is what has been prepared as RG, period. Do you have that?
Hang on, I'm getting there. I had mine separated, it's different.
It's a page and a half. It's a little over one page.
Oh, okay.
Excuse me.
Get it, Bob?
Yep,
Okay.
I got it.
Through the chair, my understanding is that there would be a reading of the resolution that the board is approving into the record, and then a motion to approve that resolution. Is that how you're asking?
I want him to reword his motion by reading the resolution that we should be approving, if we so wish. And so once he has it read in the record, we will vote on that resolution. Okay? So
Okay.
would you read the motion into the record, please?
Resolution for motion for reconsideration, whereas the order of dismissal was issued on May 20, 2016, and by motion dated May 23rd, 2016, appellants requested reconsideration to include the vacature of the P&Z Commission decision on appeal in keeping with the practice of the Alaska Supreme Court and the United States Supreme Court. And whereas in response to appellant's motion for reconsideration, the Board of Adjustment met on June 14th, 2016, and by majority vote, the Board of Adjustment agreed to reconsider the order of dismissal dated May 20, 2016. Whereas, as described in City of Valdez versus,
Oops.
Gavora?
what is it?
Gavora?
Avora?
Gavora?
Gavora.
A-V-O-R.
Okay.
That's the case that Baron talked about in.
Okay. City of Valdez versus Gavora, 692 Pacific 2nd, 959, 1984. And Peter A. versus State, 146 Pacific 3rd, 991 and 995, Alaska, 2006. The Alaska Supreme Court has adopted the practice used by federal courts of vacating the decision of the lower body in the order of dismissal when a prevailing party voluntarily moots a case without the appellant's acquiescence, and through no fault of its own, the appellant is prevented from obtaining appellant review of appellant's claim. And whereas happenstance, including the unilateral actions and inactions of the appellee and developments by appellee outside the litigation, has frustrated the appeal through no fault or acquiescence on part of the appellant, preventing appellate review of appellant's claims. And whereas vacature does not preclude appellee, State of Alaska Department of Transportation Public Facilities, from resubmitting the application or a modified application, and does not preclude the Planning and Zoning Commission from reaching the same determination in a process the Planning and Zoning Commission deems due under future circumstances. It is now therefore resolved that the order of May 20, 2016 be supplemented by vacation of Planning and Zoning Commission Resolution Number 2015-041, retroactive to May 20, 2016.
All right. Having moved, Mr. Haxby, you will second that. All right. Is there any further discussion regarding this resolution? Mr. Stewart,
None.
anything further? Mr. Haxby has nothing either. I have nothing further to add at this point. Madam Clerk, would you please call the roll on the motion?
Baron Creature,
Yes.
Robert Stewart,
Yes.
John Haxby,
Yes.
And the motion passes 3-0. So we have reconsidered a portion of the motion for reconsideration. The second portion concerns the return of the fees. Now, AMC 2103-050A-4C provides that all costs and fees shall be returned to the appellant if the decision of the lower body is reversed in whole or in part. And that is presumably what the appellant bases its request on. So I will entertain a motion to return the money, or to direct the clerk to return the money, in the light of the fact that we have vacated the P&Z decision.
In accordance with code?
I'm sorry?
In accordance with code?
In accordance with code, yes. So if we make that motion and it passes, it will direct the clerk to return the money. If we do not pass the motion, or if no motion is made, then the appellant will be left to its own devices to seek its own remedy. I must tell you quite frankly that I'm not in favor of this, and one reason is that the clerk is not in town, and the clerk has not had an opportunity to review this, and I'm very hesitant to direct the clerk to do anything without her input. And I'm talking about Barbara Jones. I know that Lisa Schleusner is taking her place this week, but I don't think it is a fair thing to do to put a deputy into the hot seat here in this regard. But I will entertain a motion if you so desire.
If we have that motion, is that something that we can defer until we get input from the clerk?
It would require then another meeting. Ms. Tucker, any thoughts on the matter?
I'm thinking that the board doesn't have to make an order, that the code stands for itself, that the appellant, you'll have a decision, the appellant will have a decision, as I have talked about in the advice to this board. I think that the vacatur of the lower board's opinion is tantamount to reversal in whole or in part. I think that the clerk is a competent person and can implement the code here without any direction from the board. And so that an order from the board isn't necessary, and if the clerk has a different reading of that, the clerk has other counsel available for that reading, and can support that through the offices of the municipal attorney. And so I don't think that this board has to weigh in if it's not comfortable doing this.
Mr. Stewart.
Do you think it's advisable for us to even address whether or not this decision is tantamount to reversing or changing the P&Z decision?
Well,
Go ahead.
I think that this board can weigh in on that and put its opinion on the record if it wants to. I don't think that it's necessary, if the board isn't comfortable doing that.
I must tell you, my druthers would be to leave the matter where they are at present. I'm not comfortable directing the clerk to do something here which has not been passed to the clerk beforehand, and with regard to which the clerk has not had an opportunity to respond. And so I agree with our counsel's thoughts that if we leave things alone, the appellant can deal with the clerk on their own and presumably reach a resolution in some fashion. It's therefore my intention that even if a motion is made here, that I would vote against it. Because, as I said, I want to leave things alone. Mr. Haxby.
And I would not second it.
Okay. Mr. Stewart.
I have one more question, and this one is for our assistant clerk. Is the clerk's office currently working on, or have they done any procedures that address this issue at all?
We have had a case in the recent past where we have returned some fees, cost and fee. There's a fee and then there's a cost bond, but it was wholly different in nature. This is unique. The situation is unique. The clerk's office receives the bond as a way to offset the cost of copying. So in this case, most of the bond and the fee has already been spent on the enormous amount of copying that we did in this case. So the money spent, in this case, it would come down to, the municipal clerk's office would absorb those costs, which are now in about the range of about $2,000 something.
Okay. Does that answer your question?
That helps.
All right. Mr. Haxby, anything further?
Not on this particular,
Okay.
particular issue, but on,
All right.
on the former decision, yes.
Okay, I will then entertain a motion. If there is anybody interested in making a motion concerning the fee issue, do I hear a motion to direct the clerk to return fees and costs to the appellant? Do I hear a motion to that effect? Hearing none, the matter dies of its own without a motion having been made. All right. We then come to the next item on the agenda, and that is, well, we will come to that. Follow up to the board's resolution of the question of reconsideration. Now, Mr. Haxby, you had something that you wanted to bring up.
Yes, in the, I believe, the May 20 decision, we had an issue in there that said if this were brought up again, there would be special consideration given to the appellant with respect to filing of new fees and costs. I don't remember the exact wording on it, but there was something to that effect. Because we're vacating the P and Z, that would no longer be applicable in a future case. And so I would want that removed.
Well, I can,
Rescinded or whatever. I mean, there is no reconsideration because we're not gonna be reconsidering the case again. It's gonna be an entirely new case.
that is presumably what it would be, but what do we know what inventive lawyers can come up with? But it is our intention that what we have done is we have vacated the P and Z decision.
That's correct.
We have not directed that the original application by DOT and PF be vacated. We have said that it is deemed withdrawn. Okay? Now, the only thing that we have said at our previous meeting was that if the existing application is somehow being revived, that the appellant is to get notice. We did not say that they are to get special consideration or anything of that sort.
My comments are withdrawn.
Okay. Anything else, Mr. Stewart?
Yeah, I just, for the record, I don't see a conflict at all between the two.
Nope.
Yeah. I must tell you, I don't see a conflict. Anything further regarding this matter of reconsideration of our decision of May 20, 2016? No? Okay. Member comments? Anything at all that you wish to bring up at this point? Mr. Stewart?
I'd just like to thank our counsel, Julia, for
Oh,
doing all this work and
definitely. I
Good
think
job.
all of us
Education.
do.
Like the chair, I did not come across this doctrine of vacatur on mootness, and so I apologize to the board for that. And like the chair, I'm grateful that I got to learn something new, and it was actually quite fun to research because sometimes you don't, unless you have something in particular, you don't come across these judicial doctrines. And with the board at the last meeting, I know the board, from my hearing, was really struggling with the equities, and I didn't have that in my back pocket to throw out to you. So
Well,
I
thank you.
had a good time coming up with that memo for
Yes,
Barrington,
yes.
and it always
And-
is.
And just to follow up, I must tell you, if it weren't for the appellant's motion for reconsideration, we would have never stumbled across this doctrine. And so I'm appreciative of the efforts of the appellant And I know it is at times frustrating that the procedure of this board does not allow for oral argument or presenting evidence at a hearing or anything of that sort. We are strictly governed by the ordinance, which requires us to decide matters on the basis of the written record and nothing else. I can tell you that in many previous cases, the parties have come up to me afterwards and have said, why won't you allow any oral argument? We had so much to say, and I can simply point to the ordinance and say, we are not allowed to do that. And so it is for that reason that in this case, as in all others, we cannot consider any oral argument or presentation of evidence at a hearing to consider the main matter at issue. Now, having said that, however, there is an opportunity for audience participation as long as whoever wants to speak does not address a matter that we have adjudicated. So in other words, you cannot discuss the matter that we just decided or anything surrounding that. Other than that, I invite public comment at this point. Anybody? Anybody who wants to talk?
Bye.
After all of this, I have intimidated everybody, and so nobody wants to talk. That's fine. I appreciate the panel members coming at what amounts to fairly short notice. As I said before, I appreciate the appellant bringing up this matter, and I appreciate our board counsel's efforts in this regard to help us wade through the thicket, and I appreciate Lisa's, the clerk's, efforts in supporting us here. So with that said, the matter is resolved and the board stands at ease. It's adjourned.